Hello, everyone. Welcome back to the Dialexicon podcast, a podcast where we critically engage in philosophy and correlate philosophy research to social issues that affect us all at an easy and digestible level. My name is Saurish and I'm your host. This week, we're joined by Professor Emad Atiq, who is an associate professor of law at Cornell Law School and an assistant professor of philosophy at the Sage School of Philosophy in the College of Arts and Sciences at Cornell. Hi, Dr. Atiq. How are you today?
Hi, Saurish. Thanks for inviting me.
Yeah, of course. And thank you for your time and for being here today. Before we begin our discussion, I ask all my guests this question, and I wanted to ask you, how did you get into philosophy and kind of what stood out to you?
Well, I didn't receive any formal training in philosophy until halfway through my undergraduate degree. I arrived at Princeton as an undergraduate wanting to be a mathematician. I ended up majoring in economics, minoring in mathematics. And it wasn't until the spring of sophomore year that, based on a friend's suggestion, I took my first philosophy class. The course was Introduction to Metaphysics and Epistemology. It was taught by Gideon Rosen, who ended up being one of my two dissertation advisors during the PhD. I did my PhD at Princeton as well. And I guess I was always interested in philosophical questions, questions about the existence of God, the nature of free will, the relationship between mind and world. What struck me in this course was how carefully and thoughtfully philosophers think about these issues. I remember being mesmerized by the depth and creativity and really the sincerity of philosophy. And fundamentally, I was also gripped in a new way by these questions. The way these questions were presented in this class made them seem urgent, important, as if everything hung in the balance. I felt like I had to address these questions before really doing anything else. So yeah, both the importance of the questions and the way they were being thought about really struck me in this course. And yeah, the course changed my life trajectory.
So in kind of how was that experience? Because I imagine probably the listeners, a lot of students are a lot of people go into econ obviously and in math. So what was that kind of transition like, especially because you still majored in economics, right? So what went down after that? How did you get attracted to law, and how did that kind of go? Because normally I feel like those kind of majors are separate, right? I don't know, maybe I'm just not aware, but I feel like a lot of economic majors don't go into law. Is that true?
I don't know if that's true. I think the law attracts economists. There are plenty of economists working on law. As for my own interests, I after that course on that first course in sophomore year, I ended up taking several other philosophy courses. I ended up satisfying the requirements for a major, but Princeton doesn't allow double majors, so I was technically solely an economics major. I graduated as an economics major. There's some overlap. Economics is a humanistic science, right? It's interested in people, their behavior, their interests, their needs, how they respond to incentives, disincentives. And a lot of philosophy is humanistic in a similar way. Moral philosophy is deeply concerned with people and their well-being. So there is some overlap. There's significant overlap. Arguably the most famous economist, Adam Smith, was also a famous moral philosopher. I happen to be very interested in his work. So yeah, I was interested in economics. I ended up, after the BA, I ended up pursuing an MPhil in philosophy. I went to Cambridge and did a master's in philosophy. And then I went to law school, obtained a JD, and then I went back to grad school. I did a PhD in philosophy. So I jumped around a bit. I guess I'm easily excited and interested in questions, and yeah, my interests sort of range across disciplines. I think that's manifested in the work I do now, right? I'm appointed, as you noted, in both a law school and a philosophy department, and my work sort of is interdisciplinary, crosses disciplinary boundaries.
Yeah, so more on like this interdisciplinary like question, I kind of wanted to ask like the way in which like your background about like as a lawyer, like
Mhm.
has philosophy helped you with your training and your experiences in law, and like and vice versa, has law or I guess yeah, has law helped you with your philosophy research?
Yeah, so I work in a few different areas of philosophy. A lot of my work is in the philosophy of law, and you can't do philosophy of law well, I think, without knowing something about the law. You know what the law is, you know why it is the way it is, things you learn in law school. So my training in law school is really essential to the work I do in legal philosophy. And I don't practice law. I'm licensed to practice. I'm trained in law, but I primarily teach law to JD students here at the law school. But like I said, my philosophical work is very much informed by my legal training. I
So
can
how does that
yeah.
So how does that work? Because like I know for a lot of bioethicists, like a lot of bioethicists are not like medical students. I know, of course, some of them
Mhm.
are, and like
Yeah,
it would definitely help to have that background. So like in the field of like legal philosophy, which we'll explore in a second, just like the definitions and stuff. But like in that field, are like almost all the philosophers like lawyers as well, or like what's the kind of like the split, and like is there a necessity to be a lawyer to kind of engage in that activity or engage in those like philosophical questions?
mm. That's I'm not sure about the sociological question. I'm not sure. I think uh, my own feeling is that doing philosophy of law well requires knowing a great deal about the law. I worry about philosophers writing about law who haven't had appropriate training, who haven't been sort of who aren't sufficiently embedded in legal practice. An analogy might be helpful. They're philosophers of physics, right? Philosophers who write about physics, who deal with problems, philosophical problems as they arise in physics. It would be strange to find someone doing philosophy of physics without knowing something about physics. I think it's this, this is true of most subject specific philosophies. You need to know something about the subject matter. How much can you get away with, not to knowing something, but not, enough to get some sort of law degree, be licensed to practice? Maybe, maybe not.
No, I think like that kind of just makes sense in general. Like if you logically think about it, right? Like obviously you're gonna need to know about the law if you're gonna talk about the law, and like especially like doing a deep dive into it, which philosophy often tends to do. But I kind of wanted to like ask kind of a question, like a career question almost, which is like, if there's the opportunity of like practicing lawyer, like being an actual practicing lawyer and like doing philosophy, are there like actual firms that employ philosophers who work on legal philosophy, or like what is the kind of, I guess, like career options that you have
Mhm.
if you're interested in these interested in these questions, and like maybe being a lawyer isn't what you want to do, but even
Mhm.
then, like are there
I see. I see.
options for you to do, or is it
No,
just
right.
academia?
So no, no, not at all. I think law school is is an attractive option for philosophy majors. Many philosophy majors end up in law school, and they find that the training they received in philosophy helps them in their legal work. The philosophy is very much a path to law school, and the study of philosophy is useful for many things. Philosophers undersell sometimes the practical relevance of the skills you acquire in studying philosophy, but the skill of thinking carefully, thinking logically, reasoning through problems in a systematic way. These are perfectly general skills that are useful really in any area, in any line of work, and certainly in law.
So I wanted to talk about kind of like legal philosophy as a whole,
Mhm.
and like what is the field? What are some of the questions that the field is interested in asking? And are there different branches in legal philosophy? Because there's a lot of different parts of like like a court system, right? Like and how that functions as a whole. So like, are there different branches in legal philosophy as well?
Yeah, so I think the best way to explain legal philosophy is to describe the kinds of questions that philosophers of law tend to be interested in, and there are quite a few, right? So perhaps the most fundamental and basic question in legal philosophy is a question about the nature of law. What is law? What determines law? If we think of a legal system as a body of rules, we can ask, in virtue of what do these rules count as rules of law as opposed to rules of etiquette or rules of morality? Notice that we're not asking a question that's specific to any jurisdiction. We're not asking what makes some statute in the United States, say the Civil Rights Act, law around here. Rather, we're asking a perfectly general question. In any legal system, what are the facts that ultimately determine whether there is a legal system, what the rules of law are? Philosophers have given different answers, different kinds of answers to this question. Some think that it's the social facts that determine what the law is. The law of a jurisdiction is determined by what people within that jurisdiction, within that community do, what rules they obey, which rules they enforce via the threat of sanction. Others think that law is fundamentally a moral phenomenon, that you can't have rules of law unless these rules aim at general welfare or morally good outcomes. So there are different views on the essence of law, the grounds of law. These questions about the nature of law are referred to as questions of general jurisprudence. But there are other kinds of questions that philosophers of law tend to be interested in. There are questions that arise that are specific to individual bodies of law, right? So we have the law of contracts, the law of torts, constitutional law, criminal law. These are different bodies of law that arguably serve different functions, and they raise unique sort of puzzles and questions. So take contract law. An obvious question that contract law raises is, well, why do we enforce contracts? If you promise to sell me your car for $2,000 and later change your mind, why should the law force you to keep your promise? To what extent? This is a normative ethical question, but moral and political philosophers have historically had something to say about it. We also, when you study these individual bodies of law, you discover that the law invokes concepts that philosophers have traditionally been interested in. So again, in contract law, the concept of ambiguity or vagueness in language is really quite important in matters of interpretation when it comes to interpreting contracts. And philosophers of language have had things to say about ambiguity, what it is, its nature. Likewise, concepts of coercion, duress, informed consent. These are concepts that philosophers have studied. So one thing philosophers of law do is they use the tools of philosophy of language, ethics, epistemology to make progress towards understanding these legally significant concepts, these basic concepts.
Definitely. I think like also like, questions about just like overall like justice and like also like kind of what the purpose of law is. Like those questions are kind of like intriguing because I think there's probably a lot of different views on it, which, philosophy breeds those things, like different views is like kind of like the purpose of philosophy almost. But I wanted to ask the ways in which, your research specifically in the field of legal philosophy, how is that interpreted, right? Because like, when we write philosophy or like, when people write philosophy, I don't really write philosophy yet, but like when the papers are released and stuff, there's also like the art of discussion of those papers or the art of like responding to those papers or the responding to the arguments made in those papers, right? And so like when your philosophical research is released and read by the audience, which may be intended scholars, whoever it is, right? Is it read as like a lawyer writing this? Is it read as a philosopher writing this? Is there a distinction between how you're interpreted as like the speaker or like the writer? Does that make a difference in how arguments are constructed or like the validity of the arguments almost? Does that make sense?
I'm not sure. I suppose you'd have to ask my audience, right? how they interpret the work. I suppose, non-philosophers are sometimes get worried when philosophers attempt to solve legal problems using the tools of philosophy, because philosophy seems alien. And there's a concern related to the one you were raising earlier about doing philosophy of law without knowing the law.
No, definitely. I think that makes a whole lot of sense. And I honestly think that like maybe this is the case actually, like it's based off of the merit of the research being done. Because I imagine that like some people are really, really smart that even if they don't go to law school, maybe that they would be able to read and whatever topic that they're talking about as a philosophy
Mhm.
major could actually discuss that in good faith with proper research, right?
Mhm.
But like I imagine that the interpretation by whoever reading it would be based off of the merit of the argument being made, correct?
Correct. Yeah.
Right.
Yeah, that's right. And I do think that philosophers should aspire to make their work more accessible. Like,
Yeah, definitely. And I think like overall, just like that's an overarching theme in philosophy as a whole,
mhm,
which is also kind of like why it's stigmatized and also is like the birth of this podcast is because of that. Just
mm,
trying to like break down philosophy into simpler terms and reflect on like kind of how it impacts us in like daily lifestyle.
yeah,
Um,
it's an admirable goal.
Yeah, thank you. And I guess like now we can talk maybe more specifically about like the legal philosophy,
Mhm,
the meat of the topic, I guess. Um, so like I've kind of been curious about like these cases and stuff like that, just because like to me it seems that like objectivity is such a vague and
mm,
ambiguous term because
it is. Yeah.
what is it like what exactly is it? For example, like when you're presenting evidence, right? Like I've watched Netflix shows where it's all about the story and the narrative that you have with the evidence, right? And I don't, maybe this is not like an accurate representation of the world, but like I imagine that like that you can actually take evidences and piece them into a cohesive story that
Mhm.
could be different from the truth, right? So how do we or at least tell us like a different narrative, right, comparative to the hard facts? So like how are we able to understand what is objectively true and what is objectively false? And then like in legal cases, what does it mean to be morally good, right, in these areas? Like is there like a because there's often a goal of like you're under oath, you're not supposed to lie, but like moral good in terms of cases, how do we analyze, how do we understand what that is?
So quite a few. There are a few questions in there. So can I just start with this? Your observation that objectivity is a slippery notion. Um, I agree, it's slippery. When people call for objectivity in legal decision making, they could mean one of several things. So just let's just let's address that question first. Like, what does it mean to be objective in legal decision making in legal cases? So think of a generic legal case as a dispute between parties, right? And the legal decision maker, the court, the judge, the jury, are invited to resolve the dispute between the parties. Right? But they have to resolve the dispute within the constraints imposed by law. There are certain rules of law that govern how the dispute should be resolved. Rules of evidence, for instance, rules that determine what kind of evidence you can look at. So one thing we might mean when we talk of objectivity in legal decision making is that we want the decision maker to accurately discern what those rules of the game are, what those rules of decision making are, and comply with those rules. So let me illustrate. So one prominent criticism of the Supreme Court's recent holding in Dobbs v. Jackson, the case that overturned Roe v. Wade and the right to abortion, is that the court was not following its own rules of decision making. Specifically, it wasn't following the rule of stare decisis, which requires courts to respect and uphold long-standing cases, long-standing precedent, even if they think that the case is wrongly decided. So that's one sense of objectivity in law, in legal decision making that is compliant with the rules of the game, the rules of law, right, that tell us how to resolve legal disputes. But there are other senses of objectivity. So in most cases, the court fact finder has to make various empirical determinations. So in a criminal case, for instance, the jury has to figure out whether the defendant was at the scene of the crime, whether he pulled the trigger, whether he did so intentionally. These are empirical determinations, and we want the ultimate decision in the case to be objective, in the sense that we want the decision to be based on the facts about such matters, not anyone's arbitrary beliefs about them. So that's a second sense of objectivity. I think there's a third sense of objectivity in law. The law doesn't just care that decisions be based on the facts. The law invites the fact finder to be sufficiently certain about the relevant facts, about the relevant empirical matters. So for instance, a jury in a criminal trial is invited to determine not just that the defendant committed the crime, the jury has to be certain beyond a reasonable doubt that he committed the crime. That's a higher standard of proof than one we might use in ordinary life. Right? You're not just being asked what you believe about the defendant's guilt. You're being asked how certain you are about the defendant's guilt. So that's a third sense of objectivity. This heightened threshold for what counts as sufficient evidence to justify belief on some empirical question in legal context, in a court of law. So there are these different kinds of notions of objectivity. And how does this relate to the question about, the way evidence is presented? Can you remind me what the second part of the question was? So you asked, what does it mean to be objective in legal decision making?
And like also like what does it mean to like be morally good in like these legal cases like that?
Oh, good.
Yeah.
So in making these decisions, the court, the various ethical norms that apply to the parties to a legal dispute, the decision maker, the judge, the jury. The most obvious ethical norm is truth telling. Right? You're under oath, you can't lie. Arguably, the obligation not to lie is not just a legal obligation, it's a moral obligation. So one way in which you can fall short of your ethical duties is being dishonest. But judges and lawyers are held to all kinds of standards that are ethical in nature. A judge cannot discriminate, discriminate based on gender or race. These are obligations with teeth. If a judge violates these norms, they're violating their oath of office, their core responsibilities as judges. So participants in a legal dispute are subject to all kinds of norms, constraints that are both legal and ethical, and moral in nature.
So in terms of like, I guess for like a jury, in terms of deciding kind of like what side to choose on, is there kind of like a manipulation of these like moral kind of base inherent moral values when presenting cases? Like, is that like a strategy used in law to kind of convince a jury? Because I feel like, again, it kind of goes back to like this question of like narrative control over that. And so like, I was wondering about kind of like the ethics of that as a whole, if you've explored that and like what that might look like, or if that's even a question in legal philosophy about like kind of maybe the exploitation maybe of like these juries' moral values.
I'm not sure I understand the question, but I'll do my best. So the law, I noted earlier that the law invites juries, fact finders, sometimes the fact finder is a judge, to make empirical determinations, right? Determinations regarding whether the defendant was at the scene of the crime, or intended to murder, or had the right intention, so on. The law also invites the fact finder to make certain moral judgments. So to give you an example, in death penalty cases, the defendant cannot be sentenced to death unless the fact finder decides that the death penalty is justified in light of the nature of the crime, the defendant's background, circumstances. The Supreme Court is on record in describing this judgment that the death penalty is justified as a moral judgment. So fact finders are invited to make moral judgments before a decision is reached, a decision regarding, the appropriate penalty once you've convicted a defendant. So yeah, the prosecutor, the counsel for the defense, the defendant will appeal to, will make moral arguments and try to convince the jury of a moral conclusion, and they rely on all kinds of techniques, some of which you might describe as techniques that systematically bias our moral intuitions. So, I'm trying to come up with an example. So sometimes prosecutors will use pictures of the crime, pictures that elicit visceral emotional reactions. The picture of a horrific murder, and these pictures are shown, or have a these pictures, when shown, systematically dispose juries to make to punish the defendant more harshly than if the picture weren't shown. Now, whether this is whether the picture has a biasing influence, or whether it's in fact contributing in some way to the jury's moral analysis in a way that's truth tracking, in a way that helps the jury reach the right moral conclusion, that's a hard question. That's a philosophical question, and yeah. So I guess the short answer to your question is legal fact finders have to make moral determinations, and in making those determinations, they can be led astray. They can reason more or less effectively about those moral questions. Indeed, I write about this stuff. I have a paper on this very question about what it means to be objective in thinking about these moral questions.
Yeah, and actually, branching off of your research specifically, I want to talk about your paper called "Reasonable Moral Doubt"
Sure.
that you released this year. So, what kind of questions does this paper kind of explore, and what are moral facts?
So as I noted, the law invites fact finders to make moral judgments. I use the example of the death penalty. A question that has received limited attention from scholars is whether these moral judgments, when they're made by the fact finder, whether these judgments should be subject to a standard of proof. So should we ask the jury to be certain beyond a reasonable doubt that the defendant should be punished, sentenced to death, for instance, or whether a juvenile defendant should be sentenced to life without parole? In other words, so the law already asks the fact finder to make a moral judgment. Is this harsh penalty justified? Should the law instead ask the fact finder to be certain beyond a reasonable doubt that the penalty is deserved? This paper you're referring to of mine attempts to make progress on this question. I think in some cases moral judgments should be subject to a standard of proof. But I'm also interested in this paper in how courts have reasoned about this question, because some of the things they've said about moral judgments and moral reasoning and moral certainty are really quite striking. So you asked, are there moral facts? What are moral facts? Well, interestingly, these courts, including the Supreme Court, are on record saying that actually, there's no truth, there's no fact of the matter about whether a defendant deserves the death penalty or not. Moral judgments aren't factual. There's no truth when it comes to moral questions. And I find that quite striking. It's a philosophically controversial position about the nature of moral reasoning, moral judgment. It's not just philosophically controversial. A wealth of social psychological research over the past decade shows that the general public is deeply conflicted about this question. People disagree about whether moral judgments are truth at, whether they're true or false, right or wrong answers to these moral questions. So one of the ways in which the court's reasoning about this question is striking is that the court seems to be taking on a philosophically and ordinarily controversial thesis about the nature of moral judgment. But set aside this question of whether there are any moral facts. We can get back to it. There's another way in which courts have reasoned about this question in a remarkable way. So again, courts are on record saying that it makes no sense to talk of varying degrees of confidence in your moral judgments. It makes no sense to ask, are you certain beyond a reasonable doubt whether the defendant deserves the death penalty, for instance? And I find that really remarkable because, in my own case, I find it entirely natural to think that some of my moral judgments are held with a high degree of confidence and others not so much. So, for instance, I'm very confident that it's wrong to force innocent people to fight to the death for other people's amusement. I'm extremely confident that's right, but I'm considerably less certain about our obligations with respect to um, uh, our obligations to donate to charity. For instance, how much of my income should I donate to charity? I don't know. I'm not certain. That seems quite intuitive to me, and hopefully the phenomenon I'm describing is not unusual. It's generalizable. um, so yeah, I'm struck by how courts have reasoned about this question, and I critique it in the paper. I think we can make sense of varying degrees of moral confidence, and we should be asking the jury to be sufficiently certain about its moral conclusions when those moral conclusions determine how defendants are sentenced. I can say more about why I think what I do. But
Well, I actually kind of wanted to talk about kind of the like kind of like maybe like a reason, or like not an argument against, but just questioning why, right? Like, moral decisions are like inherently subjective, given how morality is subjective based off of each individual. So like, how can we use it as like a way, like in courts, how can we use it? Like, is there like a standard scale, or like, is it like, it's just like moral, like confidence, and then we like average it out or something like that? Like, what is that? Like, how can we use moral decisions, really? Because it seems really subjective, right?
I guess I'd invite you to say more about subjectivity. What do you mean by um, describing moral judgments as subjective? I mean, one thing you might mean is we don't see intersubjective convergence on moral questions, right? There's a lot of disagreement about the right answer to moral questions. But that might just be because moral questions are hard and difficult. Uh, Let me ask you, so what do you mean by,
Yeah, for sure. So I was talking kind of like, for example, let's say a jury is tasked with figuring out whether someone deserves like a death penalty, maybe, or something like that. So like, some different people will have different thresholds for what is, uh, what should be punishable,
hmm,
uh, to death. Like, what should punish you? Like, what act do you have to take in order to be punishable by death, right? Certain people will have different views on that. Like, for
hmm,
example, some people are like, minor offenses obviously are not going to get you killed, or some people are also like, nothing should get you killed.
right,
Even
that's
if you have
right.
killed another person, it is inherently bad to punish you by death, right? So like, how do we decide those things? Because there's obviously inherently going to be like some sort of scale where people are not obviously in line every time.
Yeah. So obviously people disagree about the legitimacy of the death, the justification for the death penalty. Um, but in these cases, the jury as a whole is invited to determine whether the death penalty is justified. So the law invites kind of unanimous decision. So all of the jurors need to agree that the death penalty is justified in a particular case before the defendant can be legitimately punished. So one way the law handles this problem of disagreement is, well, by requiring unanimity, given the importance of the question, given the stakes. Uh, um, but how individual jurors reason about this question, the law does not purport to police to any, in any significant way. individual jurors must consider the facts. They must form their decision, they must make a determination about the justification for the penalty based on the facts in the defendant's case, the nature of the crime, the defendant's background. But ultimately, it's up to the jury, up to the individual juror to make that moral judgment. Now, one critique of this procedure of making the death penalty turn on an individual juror's moral sensibility is precisely that that we can't regulate how people reason about morality, and we might be worried that there's so much variation. Indeed, some people critique our sentencing procedures on precisely these grounds that it's arbitrary. People vary so much in their moral convictions that defendants have no way of predicting when or why they're likely to be punished in a severe way. But that's one of the reasons why I think it's really important to apply a standard of proof to moral questions.
So if we take like a specific case of that, maybe,
Yeah.
what exactly would that look like? Like, so let's say, like, I don't know, the jury comes to the conclusion that like they're not reasonable beyond doubt, like they have some doubt about the decision to pursue the death penalty. Then
Yeah.
what would the court do in that scenario? Like, how would this be like kind of implemented maybe?
Oh, then the defendant does not receive the death penalty. So the defendant cannot be sentenced to death as a matter of law unless the jury finds the defendant deserving of the death penalty, right? So if you apply the standard of proof to the determination, as I'm suggesting, then if the jury tells the court that it isn't convinced beyond a reasonable doubt that the defendant deserves a death penalty, then the defendant doesn't receive the death penalty.
So in what scenario, like, I mean, I guess there's like a whole ethical question about like if death penalties overall or even like ethical, but like, let's say hypothetically, let's say in a world where they are possible, and the jury concludes that yes, there should be a death penalty. So then the defendant would then have to receive the death penalty. Is that how it would work? It's like a yes or no kind of.
Yeah.
So what's the difference between like the status quo and like what you're proposing? Is it just the question of like whether it's beyond like like a certain threshold? Is that like what it is?
First of all, we can distinguish asking the jury, do you think the defendant deserves to die, from asking the jury, are you certain beyond a reasonable doubt that the defendant deserves to die? These are different questions. Right. I'm arguing for this second question. I'm suggesting that if the death penalty is to be justified at all, if it's justified, I'm not sure whether it's ever justified, but if it's going to be legitimate in some individual instance, it should be based on the jury being certain beyond a reasonable doubt that a defendant deserved to die. But now you might ask, what does it mean to have reasonable doubt about whether the defendant deserves a death penalty? And the paper tries to make some progress on this question. So this is a complicated issue, so let's break it down into parts, right? In a way, the question is, one question this issue raises is, what does it mean to be objective when it comes to moral judgment? When we reason about moral questions, what does it mean to be objective? Well, one clear way in which our moral judgments could be more or less objective is if they're based on empirical, true non-moral empirical beliefs. So when the jury makes a judgment that the defendant deserved the death penalty, presumably it makes that judgment based on facts about the nature of the crime, the defendant's background, circumstance, their life story. These are empirical determinations. So one clear way in which our moral judgments can be more objective is if those judgments are based on the truth about empirical matters, right? Indeed, philosophers have argued that this connection between moral judgment and non-moral judgment, empirical and naturalistic judgment, is really quite tight. That if you take two people that are exactly alike in all non-moral respects. They do the same things, they make the same choices for the same reasons in the same circumstances. You couldn't evaluate them differently from a moral point of view. Um, Philosophers describe this relationship between the moral and the non-moral as supervenience. The moral is said to supervene on the non-moral. That is to say, if you have two acts or two people or two states of affairs that are identical in all non-moral empirical respects, they couldn't be morally different. So that's all of it, which is to say is that our moral judgments are intimately tied to our empirical judgments, our non-moral determination. So we have to, in thinking about reasonable doubt on about morality, we should also be thinking about reasonable doubt, all the other non-moral judgments on which our moral judgments turn. Okay, so that's the first observation. The second observation concerns what it means to believe well or reasonably about non-moral empirical matters. So in the paper, I rely on some work in epistemology arguing that the reasonableness of belief in utterly non-moral empirical matters is a function of the stakes in a given context. What counts as sufficient evidence to justify belief in an ordinary non-moral question about an already non-moral proposition depends on the risks, the practical risk of being right or wrong, and risks associated with being right or wrong. So just as a sort of simple illustration, if I have a guest at home and they ask me, "Oh, this sandwich on the counter, is it a peanut butter sandwich?" And I say based on memory, "Oh, no, it's an almond butter sandwich." Then now I would have concluded it's an almond butter sandwich on the basis of memory. But now suppose my guest says, "Oh, I have this terrible peanut allergy." All of a sudden, my memory might not seem all that sufficient to justify my belief that it's an almond butter sandwich on the counter. I might go and check, confirm. Suddenly the stakes raised the threshold for what counts as sufficient basis for forming a belief about whether it's a peanut butter sandwich. Anyway, so in the paper, I argue and rely on this literature that tries to show that our beliefs are context sensitive. They turn on the stakes. We can combine these two observations now, that moral judgments are made on the basis of non-moral judgments, and our non-moral judgments are stake sensitive to explain reasonable doubt in a moral conclusion. So to ask the jury to be certain beyond a reasonable doubt that the death penalty would be justified is to invite the jury to be certain about all these other non-moral facts on the basis of which it's deciding the moral question, in a way that's sensitive to the stakes that the moral question makes salient. Moral questions have a way of making salient the practical stakes in a given context. The stakes in this case are life or death for the defendant. So the jury is being reminded that all of its determinations regarding what the defendant did, his background, his life story, all of those determinations need to be sensitive to the extremely high stakes. Right? The fact that if you're wrong about what the defendant did, his mental states, if you're wrong about his background, the likelihood that he'll reoffend, all these other facts, it would mean that your false beliefs caused someone's death. Right? So it's a way of reminding the jury the stakes are really high, and so it should re-examine all of these other empirical determinations in a way that's sensitive to the stakes. That's what I argue in the paper.
Okay, yeah, I definitely like that approach because like it sounds more human almost. Like it's like we're kind of respecting a lot of different, kind of things that are part of the human experience, right? Which, sometimes if you're just looking at like the objective statements, you're ignoring so many different things, right? Which, we've heard that like to bring back to kind of like social issues, like even with like the gun violence cases, we've heard moral arguments as to why losing victims are as young as me basically is terrible, right? In terms of the long lasting effects it has on the school, the parents, the community, basically everyone who is, involved in any shape or form, and even people who aren't involved, like kids around America right now are kind of feeling the effects. And so there's a lot of impact, I guess, kind of in exploring these moral questions.
Mhm.
I do want to ask you, as we wrap up this episode now, kind of like what you are doing now with your research. For anyone who's interested in like kind of exploring more about your research, what are you doing now?
So I'm interested in objectivity, what it means to be objective, as you hopefully can tell, when you're reasoning about legal questions, moral questions, practical decision making in general. What does it take for our practical decisions, our practical reasoning to be objective? And we've noted one of the ways in which our moral judgments or practical decisions about what we ought to do can be more or less objective is our moral judgments can be based on true or false beliefs about non-moral matters, right? So our moral judgments, our practical determinations are more objective when they're based on the truth about non-moral matters. But in recent work, I've become interested in the way that perceptual and sensory experience contributes to knowledge and understanding, makes us more objective. So to give a really mundane example, when I experience the pain of a headache, I have a kind of intimate, vivid, detailed understanding of what pain is like, the nature of pain, its noxious qualities, why it ought to be stopped. A kind of rich knowledge and understanding of what pain is like and why it ought to be stopped that I don't have when I'm not experiencing pain. I'm exploring in this work in these papers whether the fact that we don't experience other people's pain makes us less objective in reasoning about what we ought to do with regards to their pain. So I'm exploring the possibility that our failure to care as much as we ought to for other people's suffering, our tendency to prioritize our own interests, is explainable as a lack of objectivity. The absence of the kind of experience-dependent knowledge and understanding of other people's pain that if we had would motivate us to be better. Um, so yeah, these projects have really two parts. One is to show that there is a kind of knowledge and understanding that is tied to experience, sensory perceptual experience, and the second part involves trying to show that this experience-dependent knowledge is matters morally. Our moral judgments, our practical judgments, need to take this experiential knowledge into account. And maybe if it did, we'd be better people. Um,
Those sound like awesome projects. I'll definitely like want to read more about that because those sound really interesting, especially like the sensory experiences one. I think like
yeah.
that's a really cool idea and like project. But that wraps up our episode today. Thanks so much, Professor Atiq, for kind of being here today and like talking about everything in terms of the discussion. I really learned a lot, and I'm sure our audiences as well. So thank you.
Well, thank you for inviting me. It was a pleasure.